Hi guys, welcome to 5mantra.com, a complete online entertainment at one place. So as you all know, this 5mantra.com platform is providing you the virtual classes, and along with the virtual classes, you people have been provided with exciting and interesting multiple choice questions in the general studies subjects. So this is Rajesh who is going to explain you the multiple choice questions in the subject called polity. So these MCQs will make you to develop a critical insight on the topic, on a particular topic. And you all know in the UPSC main syllabus, this polity is a part, will become a part of General Studies paper 2, that is I am talking about paper 3. As we are moving into the multiple choice questions of the polity, so the first topic of the polity is of constitutional framework. So in this constitutional framework we are going to deal with the subtopics like historical background of the constitution, making of the constitution, the preamble of the constitution, the citizenship of the constitution, and the union and its territory, and the fundamental rights, the fundamental duties, and directive principles of state policy. This is the sub-module which I am going to deal with in this constitutional framework chapter. So in this video, I am taking up a sub topic called historical background of constitution, which is a part of constitutional framework. So coming to the historical background, the first question is, the Indian system deviates from the British concept of rule of law. So the Indian system deviates from the British concept of rule of law. So here the question, in the statement of the question, and it is followed by the four statements. You have to pick up the correct statement in that. And the first statement is, as it gives to the judiciary the power to review the wisdom of a legislature policy. Let me quote the one by one options, and then I'll explain you the options, and we are finally we'll definitely go to the end point of correct answer. So the second option is, as it does not follow a common law, and as it vests in the judiciary the power to declare a law as unconstitutional. That's the C point, and the last point is, and the last option is none of these. So in these options, before going to the correct options, we have to eliminate the wrong options with a perfect rationality. Why you should need a reason why you are terming a particular choice is wrong or correct indeed. Okay, so coming to the first choice, that is, as it gives to the judiciary the power to review the wisdom of legislature policy. Yeah, obviously, whatever the legislation done by the legislature, that is at the central level the parliament, at the state level the state legislative assemblies, if there is any state legislative council, if it also includes in the process of legislation. So in that legislation, whatever the policy made as a law by the legislature, the judiciary has the power, okay, the judiciary has the power to review the wisdom, to review the actual rationality in that legislation. So but this is the this is the theory, this is the concept we have been derived from the British concept of rule of law only. And so we cannot say that in the Indian system deviates from the British concept of rule of law. This question demands what is the component which is not a part we have imbibed from the British constitution. So first option is, we have been imbibed from the British concept of law only. The second one, as our constitution does not follow a common law. So basically this option is wrong. It does follow the common law, because as under the rule of law, there is two components under the rule of law. First one is equal protection of law, and all men are equal before the law. So all men means, I'm not at all the gender partiality, so men and women be. So all the citizens of India are equal before the law and nobody is above the law. So these two components tends to the result called it do follow a common law for a common crime. The third option is, as it vests in the judiciary the power of declaring a law as unconstitutional only when there is a precondition. If that law violates the constitutional provisions, or if that law engaged in abrogation of fundamental rights of citizen, then that law no longer can be justified, and it cannot be held by the judiciary, and it will be examined by the judiciary under the concept called judicial review, and that judicial review we have taken from the American Constitution. Okay, so under this judicial review, the whatever the law which got violated by the which is violating the constitutional provisions, which is violating the important provision called fundamental rights of a citizen, then you can no longer justify that law, and that law can be declared unconstitutional by the judiciary under the concept called judicial review. And this judicial review is the concept we have inherited from the Constitution of USA. So obviously the third option is the correct option, because we have inherited that concept from the USA, deviating ourselves from the mode of British Constitution. So the answer is C, as it vests in the judiciary the power to declare a law as unconstitutional. Basically this concept is a judicial review we have inherited from the USA. Going to the second question. Which act provided for direct control of Indian affairs by the British government? So basically you all people know that we have been ruled by the English East India Company, which is a private company. So for around for 100 years, and then followed by the British government rule. Okay, so before going to the clean explanation of that question, let me take you to the options. First option, it is Charter Act of 1858. Okay, the second option is Regulating Act of 1773. Third option is Pitt's India Act of 1784 and the Charter Act of 1833. So the first option, we don't have a Charter Act in 1858. We do have the Government of India Act in 1858. Only we have 4 charter acts, that is around 1793 the first one, 1813 the second one, and 1833 the third one, and finally is 1853. There is no such charter act in 1858. Okay, and moreover by the act of, that is Government of India Act 1858, there is a complete transferring of power from the East India Company to the British government to regulate the Indian affairs. Okay, so the first option you can eliminate the first site. So the second option is the Regulating Act of 1773. Though it is in the Indian history, I mean in the modern Indian history, it is the first legislation done to regulate the Indian affairs, but it is not having an objective to regulate the East India Company, which is a private company. Although this act has been made by the British government. See, whatever the acts or charters we are seeing in our constitutional backdrop, those are made by the British government in London, that is British Parliament in London. Okay, so and though the Regulating Act of 1770 is the first act, but the British government has no intention to regulate the East India Company in carrying out its commercial and military affairs. Okay, so the second option is also wrong. And the third option, it is the Pitt's India Act of 1784. Actually, it is the act followed by the followed after the enactment of Regulating Act 1773. So this Pitt's India Act 1784 is intended to build the loophole blocks, okay, existed in the prior acts called Regulating Act of 1773, and under this Pitt's India Act 1784, the British government has created a new body to regulate the administrative affairs of Indian territory, and that new body is called Board of Control. So through the Board of Control, the British government has established its firm control over the mechanism of, that is over the activities of this East India Company. So with this act, the East India Company came under the ambit of control under British government. So seems to be this would be the option, but let us go to the fourth option also. The fourth option is the Charter Act of 1833. Obviously by the time of Charter Act of 1833, where our Sir William Bentinck became the first Governor General of India under this act. Okay, by that time the British government has established a firm control over the East India Company in regulating Indian affairs. So the correct option is C, Pitt's India Act 1784. Clear? So the next question is followed as, under the Government of India Act 1935, the executive authority of the Federation was vested in whom? Okay, was vested in whom? Let us see. First option is the British Crown, that is the Queen. Second one, the Parliament of England. Okay, the third one is Federal Legislature. So whatever the central legislature we do have around 1935. Okay, and that is called Federal Legislature. So the fourth option is the Governor General in Council. So what is the correct option? So before going to get the correct option, I just want to say you one thing, which is a concept. So coming to the Government of India Act 1935, say this Government of India Act 1935 is also called as Blueprint of Indian Constitution, and it is a lengthy document also. okay, which was enacted by the British Parliament. Fine. So this Government of India Act 1935 has proposed the Indian Federation, but which never came into the existence. Okay. So now, right now, after the enactment of our Indian Constitution, we have been formed as Union of India. Not like there is no such federation term in our Constitution, but the Government of India Act of 1935 has proposed the term called Federation of India. That means a group of constituents in our country, that is provinces or states, will come together and form a single unit. That is called federation. Okay, the examples of modern day federation are Canada, Switzerland. Okay, so those are called the federations, where the states over there will come together and they will form into a country. So that federation has been proposed by the Government of India Act 1935, but which never came into existence. And according to that Government of India Act 1935, whatever the federation we sought to establish, it is asking who would head that federation. It is obviously the Governor General in Council. Okay, the Governor General in Council, who is a Britisher. So he would head the federation. Just like, see, heading the federation is like the President of India, the post like President of India. Heading the federation would be same as heading the state, head of the state. So before independence, the head of the state who is regulating our affairs is Governor General in the Council. Here council means that is executive council. We have legislative council and executive council, and moreover, no need to worry, because the central legislative council and the central executive council has been headed by a single person, that is our Governor General, who is a Britisher. Okay, so according to the Government of India Act 1935, the executive authority, okay, of the federation which sought to establish was vested in the hands of Governor General in the executive council. Am I clear? Cool. So the next question is, which of the following in British India proposed equalization of Indian and British members in Indian Civil Services, that is ICS? Okay, interesting question. So the following options are, first option is Lee Commission, the second one Simon Commission, the third one is Cabinet Mission Plan, and fourth one is Queen's Declaration. So seems to be good. So let me explain you the question first, and then I will explain you the options. Okay, so first question, coming to the question, it is which of the following in British India has proposed an equalization of Indians and Britishers, okay, in taking up the exam called Indian Civil Services. Okay, since it is equalization means it is an equal treatment. So what are the eligibility criteria? The Britisher would possess the same eligibility criteria will be necessary from the Indian also, and what are the privileges to a Britisher would be availed under the taking up of this exam. The same privileges without any discrimination would be availed to the Indians also. That is called the equalization of Indian and British member in the concept called taking up the exam called ICS, Indian Civil Services. Okay, so and this line has been proposed by Lee Commission. Okay, the first option, Lee Commission. See, the Simon Commission, it is the commission which has sought to review the implementation of Government of India Act 1919, and it came to India around 1927, where we have made the a famous movement called Simon Go Back. Okay, so that Simon Commission is related to that particular concept. Okay, and Cabinet Mission Plan came to India in 1946 under the leadership of Sir Patrick Lawrence in order to propose a deal where it has proposed the setting up of a Constituent Assembly to draft the Constitution by us, and also it has clearly rejected the idea of two-state theory, that is India and Pakistan partition. Okay, and it is the Cabinet Mission Plan, it is that concept. Okay, and the Queen's Declaration. See, it is the Queen's Declaration, as I told you in the first question, it is the Government of India Act 1858, where there is a transfer of power from the East India Company to the Government of India. So, okay, so and that declaration, that transaction, that is called transaction, will become under the Queen's Declaration at Allahabad Darbar in 1858. Okay, that is the concept of Queen's Declaration, and here equalization of Indian and British members in the Indian Civil Services is proposed by the Lee Commission. The first option is the correct one. Next one, the British government lowered the age limit for taking up the civil services examination to 19 years in 1878. So in which year it has got raised to 24 again. Okay, so I'll tell you a deep insight. Before that, I'll tell you the option. First option 1892, second option 1905, third option 1906, and fourth option 1924. So it is when under the rule of Lord Warren Hastings, okay, under the governor generalship of Lord Warren Hastings, the minimum age to take up this exam, civil service exam, has been decreased to 19, and under the rule and under the reign of Lord Cornwallis, okay, this age limit has been increased to 24 years. So you can directly come to the conclusion that you can take up the age of reign of Lord Cornwallis, and you can get the answer. Obviously till 1899 we can see the services of Lord Cornwallis as the Governor General in India. So obviously the first option 1892 would be the answer, okay, because it is the Lord Cornwallis who raised the minimum age to take up the exam to 24 years in 1892, and under the Lord Warren Hastings in 1878 he has decreased the minimum age limit to 19 to take up this civil service examination. Answer is first option 1892, okay. Next one, consider the following statements about the judicial system introduced by the British in India. See, it is under the Lord Cornwallis, okay, we have got a unified judicial system, army, police system, okay. So before going into the deep insights on this introduction of judicial system in British India, let me take you to the options. First option, it judicially unified India. Yeah, obviously judicially unified India. The second option is the British established a new system of law through the process of enactment and relevant interpretation of customary laws. What do you mean by this customary laws? Religious laws. In the modern times we would call them as personal laws, okay. So those are called customary laws. The third option, in general the British tended to avoid the customary laws of India. Okay, so let me explain you the each option and then we'll come to a conclusion of correct answer. The first option is judicially unified India. Obviously, the British has introduced an integrated and unified judiciary where the apex, that is the judiciary at the center level, would have the comprehensive influence upon all the provinces of our country, unifying judicially, where a single law would prevail throughout the country. So the first option is correct. It judicially unified our country. The second one is the British established a new system of law through the process of enactment. Through the, obviously whatever the law got introduced in our country has got introduced through a route called enactment of laws. Just like, see, Regulating Act of 1773, Pitt's India Act of 1784, okay, like Charter Acts, Council Acts, Government of India Acts. So in such a way, whatever the laws they intend to bring to administer our country has been brought under the process of enactment. Fine. And also, see, and also the British, whatever the established new system established by the British, saying that it is relevant interpretation of customary laws. Obviously, this whatever the new system got introduced, it has given a space, it has given the room for the customary laws, that is for the personal laws, like for the religious laws, just like Hindu law, the Islam law, Shariat law, that is, okay, the Christian law. So the Britishers has respected our religion, okay, our evolution of society on the religion lines and the communal basis, and it has given whatever the acts the Britishers has got enacted, it has given the space for the customary laws. So maintaining the relevancy of those customary laws. The third option is, in general the British tended to avoid the customary laws of India. Obviously it's wrong. So the third option contradicts my explanation just before a few minutes ago. Okay, so the answer is both 1 and 2 are correct. Both 1 and 2. First option is the correct one. Which of the statement given above are correct? So both 1 and 2 are correct. So these are the critical questions, guys, in the historical background of constitutional framework. So in the next class, I am going to explain you the MCQs from making of the constitution under this chapter. So until then, please follow our channel to get more videos, updates, MCQs mainly, and video lectures. Okay, and if you like this video, Please share this video, and if you have any queries, do comment on your comment section. And finally, raise your thumbs. Thank you.